Hi, it's Chris Jackman from the Aberdeen Law Firm, and this edition of the podcast and the YouTube, I want to talk about community property. And you might be wondering, what is community property and how does it apply possibly to my case? Community property is something that is seen in a little over half the states in this country. The other half of the states in the country have what's called separate property. And this is the kind of law that's going to apply to your case if you and your spouse are disagreeing over what I would just call things in your marriage, such as your home, your car, your retirement accounts, your savings accounts. It could be even a table or a couch. Pretty much anything that's a physical object or something that's not alive, like your children or your dogs, that's going to be considered in most states community property. And the reason why I want to talk about this in today's show is because a common question that I get from clients over and over again, and I've gotten it for years now, is, what's going to happen to my home? What's going to happen to my retirement accounts? I often hear people say, hey, Chris, my wife or my husband bought something in their name or took out something in their name, and I don't think I should be responsible for that. And what I tell people is that I say, look, that we're in a community property state. And what that means very basically is that anything that you get during your marriage, whether it's a car, a couch, even student loans, certainly a home, a 401k from your work, any kind of savings or retirement account. Again, all of those things are part of what's called community property. And so it doesn't matter if your spouse goes out and buys things in his or her own name with his or her own money, it's still considered community property. And the big picture point of that is that when you get divorced, half of whatever these things are, whether it's the value of your home, your retirement account, your 401k, the items in your home, half of that is going to be split with your spouse. And I know some people think that's just really unfair because a lot of times you might have one spouse who doesn't work at all or might make a lot less money than the other spouse. And that spouse who's not making as much or who isn't doing any kind of work at all may, again, take out things in their name, such as credit cards, or may go buy expensive things like cars and jewelry. But again, if you end up in front of a judge, the judge is going to tell you, hey, this is a community property state. And so anything that you are acquiring during your marriage is going to be split 50-50. And again, that includes your home, that includes your car, that includes even your retirement account that's through your work. So unfortunately, things are just going to be split 50-50, and you kind of have to understand that that's just how it is in the majority of the states in this country. Now, there are a couple of exceptions or things that are excluded from that rule, and I want to explain those to you because sometimes these do come up. The number one exception to this rule is that if whatever the thing is that you were trying to keep for yourself was given to you as a gift, so in other words, if you can clearly show that your Uncle Bob or your Uncle George gave you a car and it was specifically intended for you or gave you money that was intended for you, then that's yours. So you don't have to share gifts with your spouse. Now, the burden of proof, is on you, and that can be difficult sometimes, but we kind of think of justice or the law as a scale, right? And so we can't have a tie like in soccer, for example. There's got to be a tipping of the scale in your favor in order to convince the judge that you're right and that the gift really is intended for you. So sometimes that could take the form of getting whoever it is that gave you the gift to write what's called an affidavit, which is just a statement that's given under oath saying, I swear that the gift I gave my nephew or my daughter or whoever was intended as a gift. So that's exception number one to the overall rule that everything that you have is going to be split 50-50. Exception number two is if it's an inheritance. So, if your great grandmother passes away, your dad passes away, and they leave to you in their will their home or their car or their boat or whatever the thing is, that is yours individually. So even if you're married and someone passes away and you inherit a gift, that is yours. You don't have to split that with your spouse when you get divorced. The third and final way that you are allowed to keep things that are yours, quote unquote, even if you're going through a divorce, is if you got or acquired that thing prior to getting married. So for example, if you bought a home on January 1st, 2021, and you were single at the time, and then a year later you get married, and then 6 months after that you get divorced, in that case, your spouse would not be allowed to get any value of your home because you got that home prior to marriage. So those are the only real three exceptions. Number one, was it a gift? Number two, was it whatever the thing is, an inheritance? And again, the inheritance could be a home, it could be stocks, it could be bonds, it could be money. It could take a couple different forms. And number three, did you acquire or get this thing, whether it's a home, a stock, a couch, whatever the item is, before you were married? If the answer is yes, then those are the only three situations that whatever you have isn't going to be split 50-50. So I hope that makes sense. Again, that's a question that I get a lot from people, and I think it is confusing, especially, again, when you talk to people and they say, well, all of these things that my wife or my husband bought were bought in his or her name with his or her money. But I think that what you have to understand as a sort of legal concept is that you and your spouse, whoever this is, when you get married, you are considered one person. You're no longer two people. So even though your spouse might go out on some wild spending spree and buy these things in his or her name using his or her money or credit card, legally you are still considered to be one person. So it's almost as though you went with your spouse, and bought these things. A couple other exceptions that I want to bring to your attention, because that's kind of how the law is, unfortunately, is that you have a rule, but there's always exceptions to that rule. I just gave you three of them, and I want to give you two more minor exceptions to be aware of to this overall rule of community property. Exception number one is that you want to be really careful and figure out what the date of your separation is. And that's important for a couple reasons I want to get into. As you can imagine, sometimes there's argument and disagreement as to when couples will separate. Typically, the judges say that, and the law says that the date of the separation is either when you move out of the home or apartment or wherever you're living with your spouse and you're no longer living together, or when one spouse actually files the divorce documents in court. Those are typically the dates of separation. And the reason why that can be critically important to your case is that after that date of separation, in most instances, the judge isn't going to hold you accountable for purchases that were made or debts that were incurred after that date of separation. Right? So you can imagine how terribly unfair it would be if you go and you file for divorce and you move out, and then your spouse, who still has access to your credit cards, goes out and buys all of these items, then you're still on the hook for them. That wouldn't really be fair. So that's why it's critical that you figure out when that date of separation is. And if you have a concern that your spouse might go out on some wild spending spree and use your credit cards, then you might think really hard about getting a lawyer and getting into court to get a court order to stop that. So that's the biggest thing that you should be aware of in terms of these overall exceptions to a very, very tight and ironclad rule about community property. The other one that I've seen, and this is a little bit rarer, and that is the improvements to a home. So, for example, let's say you go out and buy a home, as I mentioned in my previous example, a year or so before you get married, your spouse moves into that home. If you can show clear and convincingly that, you and your spouse put all kinds of, additions and renovations into the home, and that the home, clearly increased in value because of the labor and the cost that went into that, then you've got a strong argument that the spouse should be able to receive a portion of the benefit that they contributed to that house, right? And again, that can be difficult. It can't just be your word, showing, hey, I mowed the grass, or, I painted the wall. I mean, you've got to be able to show you made substantial improvements, to your home, and that those improvements really produced, a monetary result. I had a couple cases years ago that went to trial over this issue, and we had to hire some experts to really prove that. One of whom was a real estate appraisal expert who could go in to look at the home and say, okay, these improvements to the home that were done, the appraiser showed when they were done, first of all, so that way there couldn't be an argument that maybe they were done many, many years before the marriage. And the appraiser was also obviously able to pinpoint, how much value that added to the home. So, I don't see that a whole lot in my cases, but it is something that does come up occasionally. But big picture, again, the reason why I wanted to talk to you today in this podcast was to really implant in your mind this idea that when you get married, you are one individual person. There's not much difference between you and your spouse. And this community property rule that I keep talking about is very strict. And again, it may seem unfair, it may not seem right, but anything and everything that you get during the course of your marriage, stocks, bonds, money, houses, cars, debt. That's a big thing that people don't realize, is that debt, credit card debt, student loan debt, is part of this overall community that you're going to be, partly responsible for. On a closing note, I also want to talk about the home. Because a lot of times folks ask me about, well, what if I want to stay in the home, or what if I want my spouse to stay in the home? What do we do about that? Because the house is typically your biggest asset, right? In my experience, typically judges can give you a couple options for that. If there's agreement with your spouse, then what you can do, assuming you have equity in the home, and equity just means all the down payments you've made over the years that goes towards the actual principal, not the interest, but the principal that you've paid on the home. If there's a way to refinance, with another mortgage or lending company, and take that money out and pay off your spouse for what they're owed, you can do that. The judge isn't gonna shake their head at that at all. But the big thing you got to be aware of in that case is how much equity do you have in the home, what's the value of the home. You got to be aware about interest rates, because the interest rate, especially in the past few years, were very low, and they've gone up significantly. So you may be in a situation where the interest rate that you were paying on the home was much lower than what it is now. And not only that, but if you got the mortgage with your spouse, the mortgage company is going to want to have a discussion with you about how this is going to work, because when from the bank's perspective, they loan the home to you, they loan the money to buy the home to you based off two incomes, right? And so now, if there's only one income, because now the home is attempting to be refinanced, and one spouse's name is being taken off the title, well, the mortgage company might have some real objections to that, and may not allow you to refinance. So there can be some real hurdles to having one spouse stay in a home, and that's why most of the time a judge will just force the sale of the home, because it's just there's too many logistical and financial problems that go into refinancing a home, and so that's why normally the judge will just say, hey, you know what, I'm just going to force the sale, and you're each going to get 50-50 of whatever equity is in the home. Not always fair, but that's often how it works out. If you have any questions, or if I've said anything that doesn't make sense, or that you're concerned about as it pertains to your case, I hope you can reach out to me. We can obviously sit down and have a talk and a consultation about how community property affects your case and how we can help you overall. I hope this podcast has helped you and given you some information to better arm you for your case. I look forward to talking to you again.